Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 31 of the Case a Day series journey covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Today will be a long recording as I'd like to introduce the meaning of mens rea and cover a mens rea test present in the case of R v Mohan, 1976. Firstly, mens rea is Latin for the guilty mind and refers to the mental element of a criminal offence. Every offence, unless it is one of strict liability, has both an actus reus and a mens rea. It is for the prosecution at trial to prove that the defendant had the required mens rea for the offence that the defendant has been charged with. Be aware, though, that there are different levels of mens rea, ranging from intention, which can be either direct or indirect. Just so you know, indirect intent is also known as oblique intent. There is also recklessness and even a negligence standard in criminal law, which is tested objectively, i.e. a failure to meet the necessary or required standard of behaviour/conduct. Intention is the highest form of mens rea and is the only mens rea requirement for specific intent crimes, such as murder and Section 18 of the Offences Against the Person Act 1861. Whereas basic intent crimes, i.e. assault, battery, Section 47 and Section 20 of the Offences Against the Person Act 1861, and even unlawful act manslaughter require the prosecution to prove that the defendant had either intention or was reckless when committing the offence. It took me quite a few years to learn that the criminal offence of gross negligence manslaughter is actually a basic intent crime too, despite the final component, i.e. the mens rea, or the step 4, the final step, not being proven with intentional recklessness, but with that of gross negligence. Now on to intention, and more specifically, direct intention. Intention was defined in the case of R v Mohan 1976 as a decision to bring about, insofar as it lies within the accused's power, the prohibited consequence, no matter whether the accused desired that consequence of his act or not. As a result of this, a defendant's motive or reason for committing an offence is irrelevant. The key part is that the defendant decided to bring about a prohibited consequence, i.e. they had an intention to commit the offence, regardless of why they chose to do it. For most cases, the defendant has a direct intent to commit an offence, i.e. the defendant intends for a specific consequence to occur, or the defendant wants to bring about a particular result or consequence. From this, I've always gone on to stress to my students the test for direct intent that I believe the court also went on to state in R v Mohan 1976, if my notes are correct, which was that a direct intent is where it is the defendant's main aim, desire or purpose to cause a particular result. That is the key part to take away from this recording. So, if you have a direct intent for murder, it is either your main aim, desire or purpose to kill, which is direct intent for an express malice aforethought, or a main aim, desire or purpose to cause serious harm or grievous bodily harm, which is a direct intent for implied malice aforethought. A direct intent for a Section 18 offence under the Offences Against the Person Act 1861 would be a main aim to cause serious harm. And a direct intent for a Section 20 offence under the Offences Against the Person Act 1861 would be a main aim to cause some harm. A direct intent for a battery would be a main aim to apply unlawful force, and I could go on and on and on and on and on, but you get the idea. As for the facts of this case, I don't think that they're necessary to know in regards to the multiple ratio decidendi, however you pronounce it, basically the legal principle of this case, but I'll quickly cover the facts. The defendant in this case was charged with multiple offences, one being an attempted Section 18 offence under the Offences Against the Person Act 1861, i.e. attempting to cause grievous bodily harm with intent after having driven directly towards a police officer. The police officer on duty saw the defendant driving and suspected that he was exceeding the speed limit. The police officer therefore blocked the defendant's route by stepping out into the road and signalled for the defendant to stop. The defendant at first slowed down, but when he was about 10 yards away, he quickly accelerated and drove at the police officer. The police officer jumped out of the way to avoid being hit. And that's it for today. Thank you from Law with Don't the Law Guy, and I'll see you tomorrow.